Hey everyone, Harry here to talk about the Trump administration's appeal to the Supreme Court in the Birthright citizenship cases. Now, some of the early reporting made it seem as if they were actually challenging in the Supreme Court the issue itself, setting up for court resolution and a very possible defeat. There are a lot of people, I'm among them, who think that even this Supreme Court is unlikely to side with the Trump administration in its pretty torturous reading of the 14th Amendment, which says outright in its first sentence, if you're born in this country, you're a citizen of this country. The administration, in its zeal to make it harder for illegal immigrants to stay in the country, want to be able to say the children who were born here of illegal immigrants, they're not considered full citizens. They don't have the right to public school, as the Supreme Court has held they do. And they are really pinning their argument on a second sentence or second phrase in the 14th Amendment, suggesting that they're not subject to legal process here. But that really is fanciful, it seems to me. That would mean they couldn't get driver's licenses, they couldn't be sued. That's just not the state of play of illegal aliens. So the substantive claim, I think, is far-fetched. But it's not what they've now brought to the Supreme Court. What they've brought to the Supreme Court is a festering issue that's been really playing out for years and has been, depending on which way rulings have gone, sort of stuck in the craw of Democratic and Republican administrations alike. And that is the ability, or is there the ability, of district courts to issue nationwide injunctions. So a district court can say, here's the state of law in this district. You may not do this here. This legal action I find is unlawful. I'm going to, or at least it looks like it's unlawful, and we're going to freeze it while we decide. But district courts on both sides of the aisle, as it were, this happened in the Biden administration with a judge in Texas who just issued a nationwide injunction, have been saying, and Eileen Cannon did it as well, have just been saying, okay, I agree that this administration action is unlawful, and therefore I put an injunction. The entire administration can't do it throughout the country. And it's that power, or what they want to say, lack of power, that the Trump administration is seeking to have the Supreme Court speak to. Now that they are in charge, and their actions, they don't want to be subject to having it frozen across the country. They'd rather just take the hit within an individual district. So they're going to the court and say, decide when or whether district courts can actually take claims and actually freeze or apply nationwide injunctions that keep the executive branch from acting on that law anywhere and not just in the district. So that is the issue that's in front of the Supreme Court, a pretty important one and cross-cutting. And when I say before the Supreme Court, the administration has asked them to take it up in this birthright citizenship case. So we'll see what the challengers of the law, who have won so far, are going to say to the court. But the thing to be aware of is this is about the power of district courts to grant nationwide injunctions, not about the birthright citizenship issue on the merits. So the Solicitor General for the administration is saying, look, there are these three cases, I think, and they involve different kinds of at least nuanced holding. But at this stage, the government comes to this court with a modest request. Although the merits questions are big, the court should restrict the scope of these multiple preliminary injunctions that purport to cover every person in the country, and say, look, judges, you can issue injunctions, but only to parties that are actually within your power, that you actually could assert jurisdictions over. Because the state of play here is district courts, 3 different ones, Maryland, Massachusetts, and Washington, have issued these overlapping nationwide injunctions at the behest of some 20 plus states. So it makes it a pretty strong situation and fact pattern for the administration, because not only do you have nationwide injunctions by district courts that cover areas that they don't have jurisdiction over generally, but you have overlapping ones. So it really points out the possibility for confusion when district courts can grant nationwide injunctions, because different district courts can hear the same merits claim. Okay, so that's the point here. The request now is from the United States. So the challengers, the ones who have won so far and gotten the injunction, will come in and respond to the court, not on the merits, but on whether or not the court should accept the United States request to decide, can there be nationwide injunctions, or should it be limited to the actual district that the court, where the court sits. So that, if the court takes it, they'll be deciding on the merits, and probably not until next term. And the birthright citizenship cases will go on their own pace, with that decisions being sort of on the side. So again, not about birthright citizenship on the merits, but about the ability of district courts to enter nationwide injunctions. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.